Hello friends, today I want to talk to you about the good doctor that wanted to modify his permanent alimony payments. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. About 10 years ago, I met a gentleman who was a renowned surgeon. He was such a great surgeon and he had an exceptional practice, and he earned a very high salary in the six figures high end. He was married, had children, and unfortunately his marriage didn't work out and they had to get a divorce. As part of the divorce, they agreed that he would pay the wife a significant amount of alimony per month on a permanent basis. He was able to pay that alimony payment at the time because he was still a surgeon and able to earn the salary that he had earned before. Fast forward about 10 years later, he was struck by a degenerative disease and lost the use and mobility of one of his hands. As a result, he was no longer able to be a surgeon, and he had to survive off of an insurance payment as well as his governmental sector job. He was in a position where he needed to modify his permanent alimony. In Florida, when someone tries to modify a permanent alimony, they need to show either a substantial change in circumstances or that the person receiving alimony is in a supportive relationship, which is defined under Florida Statute 61.14. We're not going to talk about supportive relationships in this video. We'll make a video about that issue. But in this video, we are going to talk about what a substantial change in circumstances may be. When someone files a petition to modify alimony, one of the first things that the court will determine is if either the person's need, who is receiving the alimony, has changed, or the person's ability to pay, who is paying the alimony, has changed. When it comes to determining whether the need of the person receiving alimony has changed, some of the factors that a court may consider is if this person is now earning an increased salary and can now pay for their own living expenses, whereas before they may not have been able to. In terms of the person who is paying alimony, like the doctor in the situation that we talked about at the beginning of this video, the court will look at a couple things, including whether or not the issue was something that was temporary, cannot be a temporary situation, and it must be something that was unanticipated. So, some examples of what may not qualify for a change in circumstances for the person that is paying the alimony may include somebody who is purposefully underemployed, or someone who got fired by their own action, their own conduct. You can't be purposely underemployed or be a jerk at work and get fired and say, well, because of that, I need to modify my alimony. The courts may not look too kindly upon that. However, there are some situations in which a court may consider to be a change in circumstances. First, a retirement. If someone retires at the retirement age of 65 or perhaps 67 or perhaps 70, a court may consider that to be a substantial change in circumstances that would warrant modification of a permanent alimony award. Next, an unexpected illness. Much like the doctor that we spoke about at the beginning of this video, if some sort of unexpected illness occurs where a person either has a degenerative disease, cancer, some sort of autoimmune disorder, that person could request a court modify the alimony award, and a court may consider that as a justification of modifying a permanent alimony award. In addition to that, an accident. Let's say subsequent to the divorce, the party who is paying alimony suffered some sort of debilitating accident where they can no longer work in the industry or job that they had previously. This is something that a court may consider and may allow for modification of alimony. And finally, perhaps the person was laid off from their job due to factors outside of their control, like the pandemic, downsizing at the company. However, courts may look at this with a little bit more scrutiny to make sure that the person wasn't laid off because of their own misconduct or something like that. Nevertheless, a person getting laid off may be something the court would consider when determining whether to modify alimony. Therefore, if you know anyone in a situation that may need to request a modification of alimony, have them look us up. They can find us at www.segarralawfirm.com. Se habla español. We have offices in Miami and Orlando. Please do us a favor and like this video, subscribe to the Divorce Broadcast, and share this video with anybody who may be thinking about modifying their permanent alimony payments. Thank you.